The National Children's and Youth Law Centre, in conjunction with the Australian Catholic University, have created a series of videos to assist students and young people to understand their rights and responsibilities as a tenant. How can I get my landlord to make repairs? Len and Anna share a house. They pay their rent on time and keep the property clean and tidy. They emailed their landlord and told him that the stove had made a loud noise while they were cooking dinner, and it had then stopped working. 2 days after they sent the email, Len called the landlord and asked when the repair would be done. The landlord told Len he was looking into it. Len thought this meant that the landlord was onto it. 10 days after Len made the call, Anna called again and told the landlord that she and Len had to do all their cooking in the microwave. The landlord was abrupt and told Anna that he would deal with it in his own time. It's now been 2 months since Len and Anna told the landlord about the stove. They want to know what action they can take to have their stove repaired or replaced. The law says that the landlord is required to keep the property in a reasonable state of repair. A reasonable state of repair depends on how old the property is, how much rent the tenant pays, and how long the property is probably going to last. However, even if the property is old or you don't pay a lot of rent, the landlord still has a responsibility to affix important things. The first step to getting repairs done is to make sure that your landlord knows about the repair. There's a part of your lease that says that you have to tell the landlord about any damage. It's good to do this in writing and to keep a copy. It's okay to send an email. The lease also explains when the landlord must make urgent repairs. These include things like a burst water service, a blocked toilet, a gas leak, and a dangerous electrical fault. It also includes a failure or breakdown of any essential appliance that is used for cooking. If the landlord hasn't made arrangements to fix an urgent repair, the tenant can get it fixed and then ask the landlord to refund the cost of the repair. There's a limit on how much you can ask your landlord for when getting things repaired. You should check your lease agreement to see what this amount is for your lease. Once you've told your landlord about something that needs repairing, they have to fix it. If your landlord doesn't fix it or doesn't do a satisfactory job on the repair, they'd be breaking a term of the lease agreement. This means you could go to a tribunal, like a court except less formal, and ask for an order that the repairs be done, or that the lease be terminated because of the breach by the landlord. If you decide to go to the tribunal to get an order for repairs, you may also want to apply for a reduced rent and compensation for any loss you may have suffered. An example of compensation that Len and Anna could claim for is money spent on takeaway food. At the tribunal, you'll need to show that the landlord breached the lease agreement. This means that you have to show evidence that the broken part of the premises is not in a reasonable state of repair, and that your landlord knew or ought to have known that it needed fixing. You can prove this by photographs, emails, letters, and records of any conversations you may have had with them. If the repair is very serious and you want to leave the property, you can also ask to terminate the lease. Remember, everyone's lease and rental questions are different, and the law changes often. If you have a specific question about your housing arrangements, please send us an email. You can read more about the National Children's and Youth Law Centre and what we do by visiting the web address provided. The information contained in this video is general, and it is not intended to be advice on any matter. If you have a specific question, please email us at the details given.